All rise.
Mr. White, you can come on up to the front. Everybody be seated, please. Thank you. Since we're going to have some questions for you, will you raise your right hand so you can be sworn? Do you swear or affirm that the testimony you're going to give will be the truth, the whole truth, and nothing but the truth?
I do.
Would you state your full name, please?
My name is Martin G. White.
Right. And what is your business address?
It is, let me look it up because it's a mailing address. I work out of my home in Orlando.
Is it 10524 Moss Park Road,
Yes, Your Honor.
Suite 204-143?
Yes, sir.
And that's Orlando, Florida?
Yes, sir.
And is your bar number 788791?
Yes, Your Honor.
Okay. We're here to find out why sanctions should not be imposed upon you. And that all relates back to the Solomon versus State case, which is our case 2024-3057. You were counsel in that case at one time, correct?
That is correct.
This court sent out orders requiring you to file certain amended documents. Did you get those orders?
I did.
You did not respond to those orders.
I did not.
You got several orders telling you to file amended pleadings, correct?
I did.
After that, ultimately, your client's case was dismissed. His appeal was dismissed, wasn't it?
Yes.
Because you hadn't filed the papers you ordered to file.
Yes.
After that, we issued further orders requiring you to tell us, to explain to us why that had occurred. You got those orders.
Yes.
And until our most recent order, which was probably our at least second, maybe third order, telling you to respond and explain yourself, you didn't respond until yesterday afternoon. Is that correct?
That is correct.
Okay. And I will tell you, I appreciate the candor of your response. And I know you said you had no explanation, but I got to know, how is it that a lawyer, and you've been practicing 20 years, right?
Yes, sir.
How is it that a lawyer gets orders from the court telling you to do something? Let's start first with filing amended pleadings, and you choose not to. Can you explain that at all?
Your Honor, my reason for that would not excuse my action or inaction.
I just want to know. I mean, I practiced law for a long time. If I got a phone call or a letter or an order from a court telling me to do something, unless I thought I should take an appeal, I would do it or try to do it. And we very rarely have this happen. And if it does happen, oftentimes there's some kind of a mistake. You're not getting your email, or you're sick, or thank goodness it's not the case here, you're dead. We have people who don't respond and go, what in the world's going on here? And we go on the bar page, well, unfortunately the counsel passed away. But to get an order and just not do anything.
Your Honor, I thought that once Mr. Solomon's attorney would come into the case, that would be the extent of what I needed, that would end it. Even though the orders came in, my thought pattern was that Mr. Solomon was in the process of hiring an appellate attorney. Once he comes in, or she comes in, then that would release me, and that was wrong. Secondarily, there is
And again, in terms of us, when we got to the point of telling you to explain yourself to us, I understand your thought process there, not that any of us, including you, agree with it, but when it got to the point that we're saying, Attorney White, tell us why you're not doing this, you didn't think the new counsel was going to answer that question, I don't think, did you?
No, Your Honor, I did not.
Okay. And until our clerk's office called you yesterday, you had received the order that you were supposed to be here today before anybody called and left messages, correct?
Yes.
And you were planning to come anyway, I hope?
Yes.
Okay. Glad to hear that. But until yesterday, you didn't even file a response when we asked for just a short postcard, 5 pages kind of thing.
Yes, Your Honor.
And you understand, for us, our system works, our system of justice works when people do what they're supposed to do. When we tell you you need to file a different pleading, it's because there's a reason for that, a need for that. We don't just run around telling you to do things. And when we ask you to explain why you haven't done things, we need to know why. Again, sometimes there's an error. We're not getting the right email, or there's some problem on your end with your email. And that's why we ask for people to tell us why and what's going on. And when we hear nothing, instead of dealing with cases like your clients, we have to deal with you, and we're duty bound by Canon 3, the Code of Judicial Conduct, and more particularly, Canon 3D, subsection 2 says, a judge who receives information or has actual knowledge that substantial likelihood exists that a lawyer has committed a violation of the rules regulating the Florida bar, we have to take appropriate action.
I understand.
And you understand, under the Florida bar rules, you have to diligently represent and communicate with your client. You have to be competent and prepared and carry out your duties. And you also have an obligation to the tribunal to obey the orders of the tribunal, or if you disagree with them, take an appeal. And when you don't do all that, and again, it's for the bar to decide, but that certainly appears to me as a likely violation of those rules, and under the canon, we may be obliged, and I hope you won't be surprised if we do have to report this matter to the bar, for them to take appropriate action. We're not trying to tell them or you what the appropriate action is, but would you like to make any kind of statement to the court?
Your Honor, as I wrote in my, I don't say motion, but as I wrote to the court, I take full responsibility for the things I did and or did not do. There is a medical issue that, to be honest, it does not excuse it, and I'd be too embarrassed to bring it out in open court, but I am responsible for what I do or don't do. It's really that simple. I made a horrible judgment in what I, again, did or didn't do. It's on me.
All right. Well, I appreciate that. We all three looked on your webpage and saw what the nature of your practice was, and that you were a police officer for 20 years before that, which we thank you for. I did not see in your areas of practice that you hold yourself out as an appellate lawyer. Is that
Yes,
correct?
Your Honor. The idea was for me to file the notice because I believe it was getting close to the end of the time, and that my client was going to bring on another attorney that doesn't keep me from actually having to follow the rules of the court. I believe it's 9.140D.
And the other thing too, that again, sometimes lawyers are in that circumstance where they were trial counsel, they filed a notice of appeal and plan to leave. If somebody in that situation starts getting orders from us, you still need to respond.
I
And
understand.
the appropriate thing as well would be to withdraw from the case if you have no plans on representing the appellant on the case. Thankfully here, new counsel got his appeal reinstated, so I wouldn't say there's no harm, but it's not the harm that it could have been.
Yes, sir.
So I don't know if my colleagues have anything they want to address.
I guess I'm curious, from your perspective, if you'd like to share what you think an appropriate sanction would be if the court determines that sanctions are necessary. Do you have a
I have
proposal on
absolutely no idea. This is my first time in this situation, what Your Honor said, in 20 years. I flubbed pretty good. I have no clue. Basically, I came here to take my lumps.
Okay. All right. Well, we will be in recess, and I guess for the record, I ought to put on here that it's this motion, this sanction hearing is in case 24-3057, Gonzalo Solomon versus State. And I think with that, we will be in recess and we'll be issuing appropriate orders. So thank you for coming. Drive safely on your way back.
And I do apologize to the court for wasting your time.
I appreciate your attitude and your contrition. I really do. So thank you very much, and we will be in recess.
Your Honor, would I be able to head back? Or
You're free to go. No, you're free to go. You will get it in the mail. If it asks for a response or something, we have full confidence in you responding.
Yes, sir.
Correct? Okay.
Have a good day.
Great. All right, thank you very much.